At this time, let's begin today's FICO webinar, Regulatory and Legislative Developments Impacting the Collections Industry. I'd now like to introduce Daniel Nestel with FICO. Daniel, you have the floor.
Thanks, Jessica. Good afternoon. Good morning. I think that should cover everyone on the call today. As Jessica said, I'm Daniel Nestel. I lead government relations for FICO, and I'm based here in the Washington, D.C. area. I spend my days working on legislative and regulatory issues impacting our company and our clients. I interact with policy leaders on Capitol Hill as well as a wide range of DC stakeholders. Before we begin the program, I just want to acknowledge that the extraordinary times that we are all living in, and given the challenges that we are facing, we here at FICO greatly appreciate that you're joining us here today and hope that you, your family, your friends are healthy and finding ways to best cope during these difficult times. With that said, let's jump in to the program. I stumbled across this quote in preparation for this webinar, and admittedly, the content is fairly obvious. It comes from a former CEO of a multinational bank, actually in India, and she was responding to a question as it relates to the pace of change in her industry. And this seemed like an excellent backdrop for our webinar today. Now, obviously, change is a big challenge for all of us. Even before, and you'll notice she references the rapid change around regulations, and even before COVID-19, 2020 was shaping up to be a significant year as it relates to the role that public policy and regulations we're going to have on the future of the collections industry. Clearly now it's even intensified. So I thought this did a really nice job of framing what will be a far-ranging discussion today. We have, and we're very fortunate to have a public policy expert who has her finger on the pulse of what is happening in the collection space on Capitol Hill and in the federal agencies and in the states. Leah Dempsey is Vice President and Senior Counsel for Federal Advocacy at ACA International. I think all of you, or many of you, are familiar with ACA International, the leading trade association for the collections industry. Leah's work is focused on lobbying on Capitol Hill, as well as working on regulatory issues and interacting with a number of federal agencies. She's got a great background. She's held advocacy positions in other parts of the financial services industry and has worked on Capitol Hill as well. And today is extra special because Leah is taking it up one notch in terms of being a real hero. She has recently become a new mom to a beautiful baby girl. It's only been about 8 or 9 weeks, and she has been back at work during this tremendous time of change for the industry and pulling double duty. And we're really grateful that she's here with us today. So thank you, Leah, and we'll get to our discussion in just a few minutes. But first, just a few housekeeping items at the top. Slides, recording, most importantly, the survey. You will get it very shortly after this webinar, so it's coming to you soon. The agenda, as you can see, we're going to cover a pretty wide range of topics. Our objective today is to get you caught up on what's going on with some of the hot button issues, also discuss some of the emerging issues around COVID-19. We'll spend a little time with that. And then we'd like to also engage with you and have a dialogue. So please send your questions via the chat box or the question box so we can identify them later in the webinar. We want to do a poll question. So Jessica, if you could put that up on the screen, that would be great. We'll give you just a little time here to, I can read it other than the COVID-19. Which of the following is viewed as the most impactful to your organization? We about ready to close, Jessica? And maybe show the results? Great. Well, we'll be spending a fair amount of time on the number one issue. This is really helpful to see the results, and this is, stay tuned. We've got more to come on this. We're going to actually start with the CFPB proposed rule, and now I'm going to bring in Leah to have a discussion on this. We all know that after 6 years of input, discussions, industry outreach, discussions with a variety of stakeholders, consumer advocates, practitioners, the CFPB came out with a proposed rule updating the Fair Debt Collections Practice Act in May of 2019. For those of you who know the FDCPA well, you'll know that that was enacted in 1977. And until this proposed rule, there really were no accompanying regulations. So the statute was kind of in a static state for decades. And the proposed rule drew a lot of attention. Over 14,000 plus comments were submitted to the CFPB, and they are currently reviewing them. And Leah, now the hard part for you. The proposed rule was 500 plus pages. It covered many more details than we can even begin to discuss in the short period we have today. But I was hoping that you could help us break down some of the areas that the industry was pleased to see addressed.
Sure. And before I begin, Daniel, I just wanted to say thank you to you for having me here today and to the whole FICO team. I think we're kind of unique in that we may be the only industry I know of that was actually looking for rules from the CFPB. And that is because of what you said, the statute is from 1977. It's severely out of date. It does not account for things like new technology, email, text messaging, voicemail. And I think, that's a good example of some of the things that we think are positive. As most people on this call are probably aware, there is currently a catch-22 for collectors when leaving a voicemail message, in that they have to disclose under the FDCPA that they are a debt collector, but if they disclose the debt to a third party because they overhear the voicemail, they can be in violation of the law, and there's a ton of litigation in this area. So one of the positive aspects of the proposal is they have a limited content message that would solve this conundrum. It would provide a safe harbor for leaving voicemail messages. And we came out in support of that. We made a Chevron analysis argument for why the CFPB has the authority to do it. We did provide some suggestions for some improvements that we think could be made to the message. However, overall, this would be greatly appreciated by the industry to stop some of the frivolous litigation in this area, particularly since there are circuit splits throughout the country on what people can do right now. So that was a positive step forward. At a high level, the debt collection industry was also just very happy that the proposal acknowledges new communications such as email and text messaging, and even things like private social media messaging. These are all addressed in the rule. And currently, only about 15% of the debt collection industry is using email, even though it's really the preferred form of communication because of some of the legal challenges right now, because of the lack of guidance in how to comply.
That's great, Leah, and clearly we're going to get back to email and text and the whole concept of digital communications, because as we all know, there's a second prong. The CFPB is promoting it, and then we've got some challenges with the TCPA, the Telephone Consumer Protection Act. Let's turn to the ACA. The ACA, as I mentioned, there were 14,000 comments submitted. The ACA may have had the most lengthy comment letter that was submitted last September. What are the top kind of remaining concerns for the ACA and more specifically the collections industry?
Sure, and as you mentioned, we filed a very lengthy comment. It was 154 pages, so encourage anyone out there to read it. I'm not sure how many people have gotten through all 154 pages, but there's a lot in there, and we provide very substantive details on how the proposal can be improved upon. But just want to hit a few high-level things. As I mentioned, we're happy to see that email is acknowledged, but we've definitely saw some problems in the way that the Bureau laid it out. To be able to send email, you either have to comply with the e-Sign Act or this e-Sign Act accommodation, which is laid out in an electronic flow chart, which we think is very complicated, particularly for smaller businesses. So we outlined some extensive concerns about that. There's also things in there like the fact that you have to differentiate between work email and personal email. Which right now there's not a vendor that does that. So we think that would be a hurdle that would stop a lot of people from using email because they just simply couldn't do that. In the proposal, there's also a model form validation notice. And this is welcome because we've been looking for some safe harbors in this area. However, there are some aspects to it that we think need to be improved upon. There are some itemization requirements that we really think are unworkable for small businesses and particular industries, specifically the medical debt industry. We think it would be hard, so we provided some specifics there. On that form, there's also a checkbox so that consumers, without describing why they're disputing a debt, would simply have to just check a box, which we think would cause problems with people disputing debts that they really don't have a good reason for disputing, and it doesn't provide the necessary information to agencies to know why it's being disputed. So we outlined some concerns there as well. Lastly, would just want to mention the call cap of 7 calls per week. We outlined in detail why we think it's a problem that they came to this specific number of 7. The research in the proposal really didn't explain why, the number 7 was better than the number 8 or the number 6. And we didn't think it stood up to snuff in some of the Chevron analysis of proving that they were addressing a harm to consumers and showing that the number 7 was better than any other numbers. So we spent a long time in our comment letter as well. And we also outlined some states that have taken similar actions that have actually proven negative for consumers, like the state of New York. We found that after some of these requirements were put into place limiting the ability to communicate, such as the call cap, there was a rise in litigation after that. So we outlined that to the CFPB about why they should be rethinking potentially some of these arbitrary limits on communications.
Thanks so much, Leah. And again, I just want to emphasize their comment letter was incredibly extensive and well worth taking a look at if you haven't. And because this issue, it took us 6 years to get to a proposed rule, and they put out the 500+ page proposed rule, and now we have another proposed rule. This one being referred to as a supplemental NPRM, little Washington speak for notice of proposed rulemaking, addressing time-barred debt disclosures. Now, this was addressed a little bit in was addressed a little bit in the initial proposed rule, but here a separate proposed rule discussing this key issue. What were the areas that ACA intends to raise connected with this policy? I believe now the comment deadline, Leah, has been extended to June 5th, 2020. So there's still time here for the industry to weigh in.
Correct, thank you. And we actually asked for that extension last week, and we appreciate the fact that the Bureau granted it. One of the reasons we did that is we think there's some parts up to this that people really want to take a close look at, and we know that people are pretty busy right now dealing with some of the day-to-day of changes from the coronavirus. So we asked for that extension to give people time to take a look at it and hopefully comment on it. What we really were kind of hoping for here was one specific disclosure that simplified things. And what we got are 4 different disclosures that we think may actually make things a bit more complicated. I won't get into the finer details, but I'll just mention that there are some concerns that it conflicts or overlaps with state law. There are some state law disclosures that are very similar but slightly different. So it raises the possibility that collectors may have to put 2 different disclosures on a letter that are similar but slightly different, taking up space on maybe the front and back, and certainly potentially causing some confusion with consumers. There's also a know or should have known standard that we think could raise some questions of fact about what was in a collector's mind. We think that's going to be a problem. And we're also concerned that it could be causing collectors that aren't lawyers to be making really a legal analysis and legal decisions on some of these disclosures that they're using, which we think is a problem because we shouldn't be asking people that are not lawyers to be practicing law. And the last sort of high-level thing I'll mention is there are some new requirements for oral disclosures, which, you mentioned the TCPA. Those are just asking for litigation when, you're making oral disclosures that it comes back to a question of, what was said on certain phone calls. So at a high level, those are some of our concerns. Urge everyone to follow along with what ACA is doing on this, because we will be filing comprehensive comments and we are looking for feedback from interested parties.
We, on the last slide of this deck, there are some links to some of the sources that we reference. Again, because this is an open comment period, this is an opportunity for you to share with ACA International or even submit your own comment letter. This is a terribly important issue, and if I really encourage folks who haven't, there's a lot going on right now that have not looked at some of the model disclosures that are being proposed in the appendix of that proposed rule. I really encourage you to take a look, because they will have a pretty big impact on collections activities going forward. So with that, you still have some time. June is still a number of weeks away. So please, take a look at that proposed rule. So Leah, because the Telephone Consumer Protection Act is yet another rule that was enacted decades ago, not dissimilar from the FDCPA, though not as long ago, 1991. So we're coming up almost on 3 decades. The Telephone Consumer Protection Act, while the FDCPA and the CFPB is promoting the use of digital communications, on the TCPA front, we all know that if you're sending a non-telemarketing message, whether it's an automated voice message, a pre-recorded voice, or a text message to cell phones, you need prior express consent. Back in 2015, when the FCC was under different leadership, and I mentioned that we had a almost 3-decade-old rule that there had been some regulations, but a lot of gray areas. In 2015, the FCC said, we'll step up and try to clarify some of the gray areas, especially around two that were of great interest: reassigned number issue and the definition of automatic telephone dialing system. Well, they came out with their order, and ACA took a look at it. and decided to take them to court. In 2018, Leah, the DC Court of Appeals issued their decision and struck down or vacated several of these key areas, including around reassigned numbers and APDS. And there was hope, I think, in 2018, that the new FCC, and when I say new, they had new leadership as a result of the 2016 election. The FCC leadership changed, and there was hope that there would be some additional clarifications that would respond to this 2018 court decision. And here we are in 2020, Leah, and we're still waiting around. Can you highlight kind of where the industry is as it relates to the TCPA? What are we waiting on from the FCC in the short or medium term? And hopefully you'll be a little optimistic for us.
I'll try. Yeah, as you mentioned, ACA won our lawsuit nearly 2 years ago, and one of the key components was striking down the definition of auto dialer. And after that, the DC Circuit mandated this question back to the FCC, and they put this out for comment in May 2 years ago. On that docket, they received thousands of comments, not just from us and the financial services industry, but really stakeholders from across the country, all different businesses and all different industries of people that are using cell phones. So that happened, and then that summer and fall, there was congressional support for this new definition of auto dialer. In fact, the whole Senate Commerce Committee actually sent a letter urging the FCC to act on this issue. So we got to 2019, and during Q1 and Q2, I think we were really thinking that we were going to see this order come out from the FCC, providing the clarity that everyone needs defining auto dialer. However, right at that time is when all of us throughout the country started being plagued by these things called robocalls, these illegal and fraudulent calls that are very annoying to everyone. And unfortunately, right at that same time frame, I think the FCC was concerned that they were going to be swept into sort of the political pushback against robocalls if they did anything on the definition of auto dialer. So they really stopped moving forward with efforts in early 2019 and sort of shifted their focus to robocalls. We've been working ever since then really to get it back on their radar. We were hoping during some of the negotiations in the Trace Act that we might be able to get some language from Congress to urge the FCC to act on the definition of auto dialer. That ultimately was not included in the Trace Act. And right now they have a lot on their plate, in fact, to implement from the Trace Act. So it may even push defining auto dialer down on their list of things to do.
You're breaking my heart, Leah. You're breaking my heart.
Yeah, no, it's been frustrating. But one of the areas we were hopeful might push through on this was the fact that the Supreme Court is looking at two different cases that deal with the TCPA, and they were set to hear oral arguments early this year in both the Facebook case and American Association of Political Consultants. But as you may have heard, the Supreme Court, like many other people, is kind of closed for business right now, and they're not hearing oral arguments.
Well, it sounds like we're still up in the air on a fix and getting clarity. In the meantime, as you can see on the slide, the courts continue to be all over the map on issues like the definition of automatic telephone dialing system and other areas. Let me ask you about one kind of proactive initiative that the FCC is engaged in. I mentioned the reassigned number issue, and at the end of 2018, the FCC announced that it was developing a reassigned number database. Can you just briefly explain why this is helpful, and what's your take on when we can see this up and running?
Yes, this is something that we think in theory could be helpful if there was a safe harbor for checking this database for reassigned numbers. They put out a request for comment in January concerning the reassigned database. And, it's helpful. They did tell us who's going to be administering it. It's going to be the North American Numbering Council, but they haven't provided some of the key details, like what the cost of the database will be. So we're really waiting to see what some of the finer details are about the database to decide whether it's going to be as helpful as we hope, but it could be a step forward.
Hey, Leah, do you have any idea when you think this could we see this by the end of this year, early next?
I would say that, yeah, as I mentioned, there's a lot on their plate at the FCC. They're working through the TRACE Act mandates, and they're working from home like many of us right now.
Yeah,
so,
yeah.
Timing's all relative, but it's possible by the end of the year, but I do think it's probably several months away.
Well, shifting gears to our next topic. You mentioned robocalls. And you mentioned the TRACE Act, and we're going to get there. But the robocalls, until the COVID-19 issue really emerged over the last kind of 30 days, one of the hottest topics in Congress was this, in Congress and in the federal agencies, was a bipartisan support for addressing robocall issues. In fact, at the end of 2019, you referenced the TRACE Act, which was bipartisan, yes, I'm saying it, bipartisan Democrat-Republican support for legislation to address robocalls. And as part of that bill, there was a provision that requires the FCC, to ensure that all voice service providers implement a call ID authentication framework, which is referenced by stir shaken. Now, I've seen it also say shake and stir, which seems more comfortable to say, but the FCC refers to it as stir shaken. And in fact, the FCC today is implementing a part of the TRACE Act and is actually coming out with rules, albeit virtually, because they're not having an in-person meeting, to provide rules for the stir shaken framework to be implemented by all voice services providers by June 30th, 2021. Now, stir shaken, Leah, can you just quickly take us through this? What is it, and what's the potential impact? Are there concerns from the collection industry?
Sure, thank you. So, at a very high level, it's a call authentication framework that, in theory, should stop these illegal actors and fraudulent callers from getting their calls completed. One of our concerns is that the FCC, as they really have on some of these robocall issues, often sees the carriers as their only constituents and doesn't necessarily look to the caller community when they're making some of these rules. And especially shake and stir, it's extremely complex. It's technological developments that are maybe beyond the people that are typically working in the financial services industry and requires some pretty stiff analysis. But some of the things that we've raised to them are the fact that in this proposal that they talked about today, there's going to be this thing called a green mark checkbox that will have to be implicated for any call to go through. However, right now, when they're using analytics to block or label calls, they're in many instances getting it wrong, and they're blocking calls from legitimate callers. So a lot of our advocacy on this has been that while, of course, we support shake and stir and a call authentication framework, there are some questions about how the carriers are doing this blocking and labeling and whether their analytics are getting this right now. And we're kind of asking them to slow down and make sure that those analytics are correct before they move forward in the full implementation, which, as you mentioned, the rulemaking is expected in May, and it should be, they'll probably be seeking comments, I think, until May 15th, and then reply comments until May 30th. And they'll probably be putting something out shortly after that in accordance with the TRACE Act. So as you know, as they consider all these things, they consider safe harbors for the carriers for blocking calls. We just want to make sure they're considering the fact that some of this has not been done perfectly up until this point.
Thanks, Leah. It's amazing how many things the ACA right now is focused on in terms of regulatory responses, and obviously, as we'll get to, what has also emerged from the COVID-19 and put the TRACE Act and stir shaken as yet another one. Our survey showed that the blocking of unwanted calls is a pretty high priority and focus area for many of the attendees on the call. This was another area where the FCC, in trying to address robocalls, kind of took a proactive approach and issued an order in June of 2019 that allows voice service providers to block unwanted calls by default. Unwanted calls also being an undefined term. So this is a kind of proactive initiative. Leah, can you talk a little bit about the challenges that you've seen with this policy that are confronting the collections industry?
Yes, and Daniel, you may remember at ACA's fly-in last year, Commissioner Michael O'Reilly was there the day that this came out, and it was a surprise to us. And one of the reasons for that is that this really went against precedent for decades at the FCC, in that, you know, up until this point, the priority for the FCC is to get calls through, not necessarily to block them. And they've never before used the word unwanted in any of their proceedings for blocking calls. Up until that point, it had really been focused on illegal calls. So, you know, this was a change of precedent to say anything that was simply unwanted could be blocked. And as I mentioned before, this would be under this order based on reasonable analytics, which again, right now are not necessarily perfect. So this order came out in June. We spent a lot of time at the FCC advocating for changes during the sunshine period, which is about 2 weeks long between when they put it out and when they finalized it at their meetings. And they did make a few minor changes for the calling community that were helpful. However, in what we've seen from June until now, call blocking has gone up as a result of this. And, you know, as we'll mention later in the presentation, we did a study on this, and the problem does seem to be getting worse because of these actions from the FCC. And we're hopeful that when they do implement Shake and Stir, they maybe, you know, backtrack on some of these steps that they've taken that have gone as far as using the term unwanted rather than illegal or fraudulent when dealing with calls.
Well, Leah, you mentioned it, so let's bring it up. So I think one of the fears from industry is what is this new policy? How is it going to impact on legitimate calls coming through? And you and the ACA commissioned a study, if I'm correct. And can you just talk a little bit about these results, because they're quite eye-opening?
Yes, and you know, in meetings with the FCC over the last 2 years, a common theme of theirs has been that we've only been able to provide anecdotal evidence of this, and they were really skeptical of the fact that legal calls were being blocked. You know, I think at times the carriers were, you know, indicating that we weren't necessarily having as many calls blocked as we were claiming were blocked. So finally, in January of this year, we were able to work with a vendor, Number Century, who did a study of a number of our largest members, and found, you know, as you mentioned, some eye-popping results that 21% of lawful calls from the study were being blocked. Of those that weren't being blocked, 25% were being mislabeled. This was not only the biggest carriers, but also smaller carriers, and third-party app providers as well. So one of the problems is, particularly for smaller businesses, a lot of times they have an indication that their calls are being blocked, but without the help of a vendor or the help of someone with a technological background, it's hard to say where the blocking's coming from. And if they do know one source of their blocking is from someone like Verizon, that doesn't mean they're the only person blocking the calls. It may be a third-party app that's doing it as well. Yeah. So it's complicated, and I think our study helped outline that to the FCC, that these are the problems that members of the industry are facing.
And remember, just to emphasize this again, these are proactive efforts being employed by the voice service providers. So the customer may not be aware that any of these calls are being blocked, and that is one of the challenges with implementing this rule. Is everybody will be using different types of what they call reasonable analytics. So important work here, and a lot more work that will hopefully be done to ensure that this does not impede lawful, legitimate calls. Okay, Leah, the bane of your existence the last, 3 weeks, COVID-19. And this is obviously, I don't mean to make at all light of this, but Leah is obviously trying to adapt to a new member of her family. She's on maternity leave, and boom, this health emergency suddenly appears on the scene, and the impacts on the collection industry are significant. And we've seen that with stay-at-home orders, as well as some jurisdictions halting government-owned debt, and in some cases, halting all debt collection efforts in a given jurisdiction. So, Leah, there's a lot here. This slide is not meant to even try to capture all of it. ACA is doing a great job trying to keep their finger on the pulse of all the new developments, both within the states, in the cities, as well as at the federal level. What do you want to highlight from what's gone on in, let's say, the last month, 3 weeks? It's been incredible, the pace of new actions going at the state, local, and federal level.
Yeah, it really has. It's been the busiest I think I've ever been, and we've been having daily huddles that are these 30-minute webinars, and they've had almost 600 people on them every day, just to give you an idea of how many people are being directly impacted by this right now. As you mentioned, this is a very somber time for the country, and people are losing jobs, and there are medical problems that people have not faced before. And there's been a lot of reactive policy steps taken that include the debt collection industry that, we don't necessarily think are the right steps. I think it sounds good in a high-level piece of legislation to say that you're going to stop collection efforts and that's going to solve everyone's problems. But we all know that, stopping communication with consumers isn't going to solve their problem. The debt is still going to eventually be owed, and a lot of times, if you can engage in a communication with the collection industry, they have these things called hardship programs, where they can get you on a payment plan. They can tell you about financial assistance programs, or in the case of medical debt, charity care. But a lot of the efforts that we're seeing are trying to just stop communications altogether, which are a problem. And right now, all different states are taking actions on this. I can tell you, I'm not the state person, I'm the federal person at ACA, but we have a ton of resources on this. to keep everyone updated about what each state is doing. Just probably the most recent that had a big impact is Massachusetts. Attorney General took action that could be really cutting back on the ability to collect debt in all of Massachusetts. So that's something that we're taking a look at and providing analysis on. They've done the same in Nevada and Illinois and several other states as well. So encourage everyone to take a look at ACA's resources on those states to learn more about that. But at a national level, we're also seeing a lot coming out in terms of policymaking in the health version of the CARES Act that was being circulated early last week. There were some provisions in there that really would have restricted the ability to engage in collections. We've seen legislation from the highest ranking Democrats in both House Financial Services, Maxine Waters, and Senate Banking Ranking Member Sherrod Brown that would essentially eliminate the ability to collect during this time frame and well beyond for 120 days. So what we're trying to do, we also received a letter from Sherrod Brown last week at ACA, which we responded to, and we're kind of trying to encourage lawmakers to take a deep breath and take a look at some of the data and information about, how collections plays into the economy and why it's important for businesses, particularly some of the small business owners that are facing unprecedented challenges right now, why they need to know that at some point they're going to be able to collect on some of the products and services that they're providing. So those are some of the discussions that we're having with Congress. One other thing I'll mention is that in the CARES Act, there was a specific provision for student loan debt that is owed to the Department of Education, and there were some limitations placed on the ability to collect on that debt. The Perkins loans were carved out of that, but the Department of Education put out its own letter last week to private collectors that essentially asked them to stop collecting on that as well. So there's a lot going on in the student loan space. Credit reporting was also mentioned in the CARES Act, but was really specific at this point to a narrow group. However, it's something that we're expecting could come up in some of these next phases as the House and Senate think about more packages that are going to be in response to this crisis. And we know that they're already starting their work on phase 4, the phase 4 package right now.
Wow. Yes. If you're not a member of ACA and you're in the collections business, you need to be, because there's just so much important information that they're providing on a daily basis. It's really tough to keep up with all the activity in the states without some group doing some of the hard work for you, and that's what ACA is doing. Listen, we're at the Q&A portion of this. We have some questions in. We also have a question first on medical debt, which is another topic that has been a fairly kind of ongoing hot topic here in Washington in the States. And we'll take care of that first, and then we'll hit some of these other ones. Leah, in 2015, this issue kind of came to a head. The 31 AGs, along with, when I say AGs, state attorney generals, along with the 3 nationwide credit bureaus, entered into a settlement which was reached, which was implemented over 3 years. As part of that settlement, there was some focus on medical debts. This was about accuracy and completeness, ensuring the accuracy and completeness in credit reports. The part that dealt with medical debts was that medical debts won't be reported by collection agencies or debt buyers until after a 100-day waiting period. And then also the credit bureaus were required to remove from credit reports any previously listed collection items that had been paid or were being paid by insurance. Now, there's a lot more that's gone on. Actually, we have a slide here that kind of details some of it. Just briefly, Leah, is there anything you would like to kind of address in the area of medical debt? Because I suspect, given this health crisis that we're currently confronting, that these issues will bubble up again.
Yeah, and I think that, ACA members would agree that medical debt is a little bit different than other types of debt. It's not that you are choosing to get sick or choosing to go to the hospital and incur that debt. So in some ways, maybe it should be treated differently. And we've had a lot of discussions with Congress over the years. We've had some really good discussions with Senator Merkley, who is a Democrat in the Senate, who's introduced legislation on this. And things like waiting 180 days or 100 days, as you mentioned, those are things that ACA members have considered as, a possibility of something they would be willing to work with the Senate and the House on and, treat medical debt differently. But one thing that's been frustrating to us this Congress is that rather than engage, the stakeholders at ACA and groups like CDIA in some of these discussions, they've kind of gone ahead, in particularly the House, with some of these more extreme bills where they have basically instead said that they're going to limit the ability to report medical debt for up to a year rather than 180 days, which ACA members tell us can be problematic. They, as I mentioned, a lot of times they're the go-between between hospitals and the consumer on things like the ability to get charity care. And some of those opportunities, if you wait a whole year, they're not able to sign up for things like charity care if they wait a whole year. So there's some problems with waiting that long. And we've had some discussions with the House and the Senate on this. As you mentioned, the House has already moved forward with the legislation in this area. It's not really clear whether the Senate will be taking this up on a standalone basis, but as we mentioned, they are putting together these packages that are including all sorts of ideas from legislation. So there's nothing necessarily stopping something like this from being included in a phase 4 or phase 5 package as they work on that.
Thanks so much. So we've got some questions here, Leah. And I'll pose a few of them for you. And the first one says, the FDCPA is proposed to be amended to halt collection efforts on consumer debts. Condo and HOA assessments are classified as such debts. They will be destroyed if they're not recognized as non-consumer debts. Any thoughts on this? Has this been on your radar, Leah?
There's been so many different pieces of legislation out there on this, and I think from our perspective, a lot of them, they sound like they're a good idea, but as I mentioned, these are things that, I think we need to have all stakeholders as part of the discussion in Congress before they move forward on these. So, something like this, I think we would want to get some more feedback on, and before we really took a viewpoint on it.
It was condo and HOA fees part of, do you remember whether that was part of the ACA response at all to the proposed rule?
I don't believe we addressed that.
So it sounds like something maybe that industry needs to provide a bit more feedback on. May not be on. Okay. We invite that, feel free to reach out to ACA and Leah so she can better understand that message. We got a question here, Leah, regarding the 7 calls per week. Is that 7 messages or 7 total calls? This is the whole, when we refer to 7 contacts, there's a bit more detail needed as to what we mean by that, or what the CFPB means by that.
No, that's a great point. And I think it's, if you make a connection with the consumer, but there is some additional clarity that people were looking for on whether if, for instance, a voicemail message picks up, that would be a contact even if you weren't able to connect with someone. So when you say 7, it can really be much more limited than what you may be thinking about for 7 calls.
and Leah, just so I don't have the rule in front of me, it's 7 attempted contacts, right? And then if you make contact, there's then was it 7 days? You had to take
and that's an
out?
important point. It resets the clock when you make contact, so you then have to wait an additional 7 days, and that was a huge concern in what we addressed in our comments.
Yeah, I think reading the comment letters and reading the CFPB rule here, this is going to be one about the 7 attempted contacts. The devils are in the details there, and that is going to be a key provision or point of contention as in an area that is going to be closely focused on when the final rule comes out. Have there been any guidelines reported for collections during the COVID-19? Any delay or in reporting or changes? My hope is that you got a little bit of flavor from our slides that there's a whole lot going on in COVID-19 around guidelines for collections. Leah, do you want to say anything further other than there's just a whole lot of action going on with some states halting collections or trying to halt collections altogether? Some government-owed debts are not being collected. The federal level, you have student loan, the Department of Education kind of ceasing all collection efforts. Anything else you want to mention there?
No, I think that's right. I think it's really specific to the action that's taken right so far for COVID-19. So, if they took a specific action, as you mentioned, for something like student loans, that might have new requirements for credit reporting. But there hasn't been necessarily a blanket new change that's been made. But there's been lots of little, I would say, cuts and, carve outs to that right now, and you have to kind of take it on a case-by-case basis.
There is one other question, and probably needs some clarification. On the screen that I'm now on medical debt, Senate Bill 1581 talks about requiring the removal from credit reports of paid medical collections. We should indicate that is a proposal. It has not been final. It has not been incorporated into a bill that's been enacted. So, Leah, I assume, as you've noted, that these provisions that have been introduced, whether it's 3621, which has passed the House, as 1581, the medical debt relief that's been introduced, all of these provisions might end up or might be in debate to be included in a future bill, especially during this COVID-19 crisis. Anything else to add there?
The only thing I would say is with some of these standalone bills, right now the process for moving those forward requires a markup in committee and a vote in committee. And because of social distancing right now, none of the committees in Congress are scheduling hearings or markups. So,
yeah,
if they're not included in the COVID-19, those packages, it may mean that they actually aren't addressed anytime soon because they're not going to probably be holding hearings very soon. So that's what we're all taking a close look at right now in terms of these packages in comparison to when things get back to regular order.
So I want to thank you for the questions, everyone. I want to end today's session with a quick lightning round. I've asked you a bunch of questions, and I want you to take 15 to 20 seconds here. Do you have your crystal ball out, Leah? I'm going to ask you, first question. The CFPB is saying the end of 2020. I saw Director Kraninger in her latest kind of debt collection report, annual FDCPA report, say in her intro that the CFPB final debt collection rule will come out by the end of 2020. Yes or no?
I'm hopeful, yes.
We got a yes there. So she's looking forward by the end of the year. Will the contact limitations that we've been talking about, these 7 attempted calls per week, will they be decreased, or are they going to stay the same? What's your, just crystal balling it, Leah?
We're hopeful that they listen to our feedback, but I wouldn't be shocked if they did not change.
Okay. Will the FCC's call blocking by default still be a problem in 2021?
You know, it really depends how Shake and Stir turns out. To me, it does not seem like they've solved that problem yet at the carrier level or at the FCC level. So I'm sadly going to say yes.
Okay, final question. Will the FCC issue an order clarifying at least some aspects of the TCPA in 2020? I'm hopeful that maybe some of the Supreme Court litigation will force them to do that. That's my biggest hope at this point, I think, is for them to be forced to act by the courts. Fantastic, and really appreciate your optimism there. Final slide, which you will all get, is policy resources. We did reference a number of regulations, legislation. Here are some of the links that you will receive. Leah, can't thank you enough for joining us here today. For all those who attended, thank you so much. We hope that you found this helpful, and really look forward to your feedback from the survey. Jessica, I think we've reached the end of the hour.